All right, we're going to get started. Hi, everyone. Welcome. Thank you for joining us. This is the National Women's Law Center's Legal Network for Gender Equity, and we're very excited to present to you this webinar on Title IX and sexual harassment, school complaints, OCR complaints, and litigation. So thank you so much for joining us, and I'm thrilled to announce our panelists for today. First, we have Alexandra Brodsky, pronounced she, her. She's a staff attorney at Public Justice, and you have her contact information there if you want to reach out with questions. We also have Shwali Patel, pronounced she, her. Shwali is Director of Justice for Student Survivors at the National Women's Law Center. We also have Carrie Simon, pronounced she, her. Carrie is an attorney at the Fireberg National Law Group. And I'm very honored to be moderating today. My name is Elizabeth Tang, pronounced she, her. I'm Senior Counsel at the National Women's Law Center. Before we dive into the content, just want to say you can all adjust your screens if you want to only view those people who are on video. You can access the view settings in your Zoom so that you can hide non-video participants. And please feel free to put all of your questions or comments in the chat throughout this. I'll be monitoring and we can collect questions and address them at the end of the presentation. And so without further ado, I guess we can begin. And also please note the webinar is being recorded. You should have gotten a notification about that as well. All right, so we'll get started. The Legal Network for Gender Equity, as a reminder, we are a network that connects people who have experienced sex discrimination as a student, as a worker, or as a patient. And we connect them with attorneys like you. So thank you so much for being a part of the network. If you are not part of the network, but you found out about us through somebody who is in the network, please let us know. You can contact Legal Network at nwlc.org to sign up for the network. If you sign up, you will receive intakes from people who are experiencing sex discrimination, and you can choose what types of sex discrimination you want to be involved in or receive intakes about. And that is a very valuable service that we're very proud to provide and to partner with all of you to assist people across the country. So before we dive into the presentation about school complaints, OCR complaints, and litigation, I wanted to provide a brief background on sexual harassment in schools, just to get us all on the same page. So as I'm sure all of you know, a major problem with sexual harassment is that it is very widely prevalent and affects too many students. I'll share some statistics in the K-12 context. About 56% of girls and 40% of boys in grades 7 to 12 are sexually harassed every year. Research that NWLC put out a few years ago found that 1 in 5 girls ages 14 to 18 have been kissed or touched without their consent. At the college level, we know from annual surveys that 1 in 4 women, 1 in 5 trans and gender nonconforming students, and 1 in 15 men are sexually assaulted in college. And furthermore, we know that there are high statistics for dating and domestic violence and stalking as well. And of course, these numbers are often higher for Black and Brown women, LGBTQ students, and disabled students. As for where this conduct occurs, we know that sexual harassment occurs both in and outside of school. And regardless of where it occurs, it does affect students' educational experience. So in school, we know that it happens in class, in Zoom and other virtual settings, on campus, during away games, in the dorms, and also outside of school, in private homes, in Greek housing, on social media, etc. Unfortunately, even though sexual harassment in schools is very common, most students are not reporting it. We know that only 2% of girls ages 14 to 18 who've been kissed or touched without their consent go and tell their schools about it. At the college level, 1 in 10 survivors report sexual assault to their schools. And I'm sure many of you are very familiar with the reasons for not reporting. Survivors experience shame and embarrassment. They're afraid of retaliation. They're afraid of being disciplined by their schools, by police, by immigration officials, or experiencing consequences from immigration. Many of them are concerned that their harasser might get in trouble. And they're worried about that. They might also believe that the harassment that they experienced was not serious enough. For example, if the harassment began consensually or if it involved alcohol or drugs. They may blame themselves and think that other people will not take it seriously. Many students are also not reporting to police. Students who are of color, who are undocumented, LGBTQ, and or disabled are often afraid of the criminal legal system for good reason, because they belong to communities that are often targeted by the criminal legal system. And in addition, survivors who are of color or who are LGBTQ often do not want to report their assailants if they're from the same community, because they do not want to perpetuate over-criminalization of their own community. And so that is also extremely relevant to this conversation, even though we're talking about schools, because if people are afraid to report to police, or if they don't believe the police can support them, then schools become the only avenue for relief. And so it's very important that there are rigorous Title IX processes in place and that survivors can get the help that they need through Title IX. Unfortunately, students who report are often ignored or punished instead of getting the help that they need. And we've just listed some examples, some common examples of how schools often punish sexual harassment victims. We've seen cases where students are punished for having consensual sexual activity or for premarital sex with the respondent. They're punished for engaging in reasonable self-defense against their harasser. They might be punished for expressing very reasonable and very age-appropriate trauma symptoms, which are often termed acting out. They might miss school because they want to avoid their harasser, and then they get in trouble for being truant. They might tell other students that they were sexually harassed, and then they're punished because they were not allowed to talk about it. Oftentimes, and we're seeing this increasingly, students are being punished for filing what the school considers to be a false complaint. And increasingly, they're being subjected to retaliatory cross complaints by their harasser, where, for example, a student will first file a complaint saying that they were harassed or assaulted or abused, and then the harasser or the abuser will file a cross complaint claiming that they were in fact the victim and that the survivor was the abuser or the rapist. And in certain cases, they may even file first to try to get ahead of the process. Some students are more likely to be ignored or punished than others. Again, Black and brown women, LGBTQ students, pregnant and parenting students, disabled students are often subject to stereotypes that label them as promiscuous, aggressive, less credible, and or less deserving of protection. And unfortunately, as I'm sure all of you know, students who do not get help when they experience sexual harassment often lose access to their education. They get lower grades, they end up having to withdraw from classes or activities, and eventually, unfortunately, 1 in 3 college survivors end up dropping out of college altogether. So that's just some background we wanted to set up. And then really quickly, we wanted to talk about what's happening under the Trump Title IX rule right now. These are a few of the things. Oh, looks like the screen's not showing all of it, but the 3 main categories are that schools can now, in many cases, ignore sexual harassment. And sometimes they actually are required to ignore sexual harassment if it doesn't fit the new narrow definition under the Trump rule, if the conduct takes place in certain off-campus or online locations, if one of the people does not go to the school anymore or is not employed by the school anymore. And in college and university settings, schools can ignore sexual harassment if it's not reported to a very high-ranking official. A second category that we want to quickly address is that schools are now, unfortunately, allowed to mistreat or further harm survivors in several ways. One is that schools can now treat students unreasonably when they report sexual harassment, as long as they're not treating students clearly unreasonably. Another way that schools can mistreat survivors is that schools are not allowed to provide a full range of supportive measures to victims of sexual harassment. And schools are now allowed to use mediation to resolve student-on-student sexual assault, which is inappropriate because mediation tends to place some blame, some partial fault on both sides, and can also be very traumatizing for survivors to be placed in the same room as the person who abused or assaulted them. And mediation, should typically be used for conflicts and not for situations of harm where one side is clearly at fault. I apologize that the bottom part of the screen is cut off, but Schools can now, in many cases, and must in many cases, use uniquely unfair investigation procedures for sexual harassment that are not required for any other type of student or staff misconduct. And that includes a number of things, including presuming that there was no sexual harassment, and applying a unfair standard of evidence that tilts the investigation in favor of respondents, and also in colleges and universities, having live hearings with cross-examination. There is some good news, though. Recently, National Women's Law Center and our partners got a win in our lawsuit against the Trump administration and against the Trump rule. A federal judge held that the exclusionary rule of the Trump rule is unlawful. And that is a rule that was requiring colleges and universities to exclude all oral and written statements that were made by any party or witness if that person did not submit to cross-examination at a live hearing. And so the effect of that rule was that college and graduate school survivors were required to submit to cross-examination by their harasser or their abuser's advisor if they wanted to include the statements in their formal complaint or in their Title IX interview, if they wanted those things to be considered as evidence. Similarly, it was creating a very bad scenario where respondents could exclude a confession or an apology from the evidence if they simply refused to be cross-examined. So if they accidentally texted, "I'm sorry, I did this thing. You're right, I did assault you. You're right, it wasn't consensual," something like that, then they could simply exclude that from the evidence if they refuse to submit to cross-examination. And then similarly with witnesses, if there were witness statements in text messages, emails, in a rape kit examination, in a police report, etc., if the person who wrote those statements was not available or was too afraid to appear for cross-examination, then those statements also could not be considered. However, that exclusionary rule is no longer the law because of this win in our lawsuit. And after we got this decision, the Department of Education issued guidance announcing that they would also no longer enforce the exclusionary rule. So effectively, survivors should no longer have to be cross-examined by the respondent's advisor under the rule. So that is the background we wanted to start you all off with. And now I want to turn it over to our panelists to explain more about the rule. So I'll start off with Carrie Simon to talk about school-based Title IX. We're now going to hear from Shwali Patel about how to file complaints with the Department of Education's Office for Civil Rights.
Thank you, Elizabeth, and thank you for that very helpful overview, Carrie. So hi, everyone. Good morning, good afternoon, depending on where you are. And as Elizabeth said, I will talk briefly about the Department of Education's Office for Civil Rights and their responsibilities, and focus more so on their investigatory responsibilities. I used to work on OCR, the Department of Ed's Office for Civil Rights, before coming to the National Women's Law Center. However, my work there focused primarily on policy guidance, on developing policy and guidance. So the Department of Education's Office for Civil Rights, or OCR for short, is responsible for enforcing federal civil rights laws in programs and activities that receive federal financial assistance. So in federal financial assistance from the Department of Education. So this includes state education agencies as well as local education agencies. So those are LEAs or school districts. So public K-12 schools. In colleges and universities, including private colleges and universities, because even if they're private, they typically do receive federal financial assistance through federal student aid that's provided to the student to be able to attend the institution, adult career and technical education institutions, the CTE programs, and state vocational rehabilitation agencies. And Department of Education is not the only federal agency that enforces Title IX, because Title IX conditions receipt of federal funding upon compliance with anti-sex discrimination protections in education program activities. Any federal agency that provides financial assistance to an educational program activity would enforce Title IX. So for example, the Department of Energy, where I used to work before, Department of Ed, where I also had an opportunity to do some Title IX compliance work. The Department of Energy enforced Title IX at higher ed institutions that provided funding to STEM programs, for example. So there were some graduate engineering programs or other science programs that receive funds. And so the Department of Energy would also conduct compliance reviews. Other agencies like the Department of Agriculture provides funding through free and reduced meals to K-12 schools. So they also would enforce Title IX at those institutions. But Department of Ed is really the main agency that is enforcing complaints of sex discrimination under Title IX, and also the main one to issue guidance. You may have heard about the Dear Colleague letters and other types of guidance or technical assistance around Title IX and other civil rights law. And the Department of Ed's Office for Civil Rights also enforces Title VI of the Civil Rights Act, which prohibits discrimination based on race, color, and national origin. Section 504, the Rehabilitation Act, Title II of the Americans with Disabilities Act, and the Age Discrimination Act. And in addition to investigating complaints of discrimination or violations of these laws, as I mentioned earlier, OCR also issues guidance and regulations. So the Title IX regulations being an example of what had come out of the Department of Education. Next slide. So this is a slide of the regional offices of the Department of Education. So the Department of Education, the Office for Civil Rights does have an office in DC, but there are 12 regional offices. And this is a list of the offices and the regions that they cover, the states that they cover. And these offices investigate complaints of discrimination. So if you have a client and they were attending an institution in Maryland and they have a Title IX complaint based on how, let's say, the University of Maryland responded to their complaint or failed to respond to their complaint of sexual harassment, you wanted to file a complaint on their behalf, you would file it with the OCR office in Philadelphia. Or if this occurred, if your client was in Texas when this happened, you would file in the Dallas office. So these offices not only investigate complaints of discrimination, but they also provide technical assistance. So they could be a helpful resource if you have questions about the law, or if students and families directly want to reach out to them with questions about the law, or recipients want to, educational institutions, they are available to provide technical assistance. And on the bottom of the slide, I provide a link to the list of these regional offices, and the list includes their phone numbers, I think their emails as well. So hopefully that is a helpful resource. And next slide. So this is a slide that's focused on OCR's enforcement. So OCR, as I mentioned, processes complaints of discrimination, not only under Title IX, but other complaints of violations of other civil rights laws. And when they process these complaints, they first evaluate them to ensure that the complainant is raising a complaint of discrimination under one of the laws that they enforce, and that it meets other jurisdictional requirements. They then investigate the complaint. They often do resolve the complaints with the parties by entering into a resolution agreement in many cases. And this is an agreement with the institution that's has violated the complainant's civil rights, or that has violated one of the civil rights laws that OCR enforces. They may enter into an agreement with OCR and agree to take a number of steps to come into compliance and to remedy the harm. And OCR would then monitor the resolution agreement, and for example, and to monitor whether or not the recipient is remaining in compliance with the resolution agreement. And this process is governed by the case processing manual. So there is a link to that in the slide. And this is a very helpful resource that details the reasons why OCR may dismiss a complaint. It provides a lot more detail as to the process. It's kind of like your go-to manual if you are filing a complaint with OCR. And there have been some changes that were made to the CPM under the earlier administration, under the Trump administration. And we are hoping for a few to be undone. But as of now, the latest complaint, the link to it is available. And I think we can also I think the slides will be available. And if it would help, I can also reshare these links at the end of my presentation. So complaints must be written and filed online. And here's a link again on the slide to where they can be filed. And it would have to allege discrimination under one of the laws OCR enforces, and it has to involve an institution over which OCR has jurisdiction. So again, this is going back to one of the first slides that listed the type of educational programs that OCR has jurisdiction over because they receive federal financial assistance through OCR. And so that does, while it includes almost all colleges and universities, most that are private, including religious institutions, because they receive federal money through through financial aid, it doesn't typically include private K-12 schools because they don't have that same type of arrangement for a federal aid to cover attendance. Although with the pandemic, there was some money given to private schools, K-12 institutions through relief funding. That did mean that they then had to comply with OCR for that amount of time that funding was being used. So that's kind of like an asterisk that I wanted to add to that point. And these complaints also have to be timely, generally filed within 180 days of the alleged discrimination, unless a waiver is granted. And again, the case processing manual kind of provides the list of the reasons for granting waiver. For example, one could be if, during this time, the complainant had some sort of incapacitating illness, they may be able to seek a waiver. And this is actually one part of the case processing manual that did change during the last administration and related to Title IX sexual harassment complaints. There was a change that the 180 days has to be following the date of each alleged incident of discrimination, whereas before it used to say the latest date. So if there is a student who is experiencing multiple types of discrimination, harassment, earlier under the CPM, it was clear that the 180 days would start after that last incident. Now it's not the case. So that is one change we are urgently seeking with the current administration. And you would also have to seek consent when you're filing on behalf of a pertaining to another person. So if there is a pending complaint with your school, however, so Carrie talked in great detail about how what the Title IX process it looks like at the school, and things to consider if you were to represent a student in their school process. So OCR doesn't handle cases that are being addressed by another agency or within a school's or college's formal grievance procedure if it anticipates that they'll provide the resolution process comparable to OCR's. But once a complaint process is completed, then the case processing manual states that you would have 60 days to file your complaint with OCR. And if there is a federal complaint, and I know Alexandra will talk more about complaints filed in court, OCR may dismiss it if the complainant filed their complaint in federal or state court, and it's based on similar allegations to the complaint that they seek to file with OCR. And they would advise the complainant that they could refile their complaint with OCR within 60 days of the termination of the court proceeding, if there's been no decision on the merits of the case or settlement of the court complaint. During these investigations, OCR is a neutral fact finder, so they collect and analyze relevant evidence. They could collect documentary evidence. They would conduct interviews. They would at times could do on-site visits and conduct interviews there, receive relevant documents there. And then OCR, in issuing a determination or a letter of findings, so in making their findings, will determine by preponderance of the evidence if the recipient violated the law. And when they issue these letter of findings, they are not formal statements of policy. However, they could be useful to advocate with schools certain changes that they should make based on how OCR has resolved certain cases. So for example, if OCR investigated a school for a Title IX violation and in their letter of findings determined that certain actions by the school violated Title IX or inaction by the school, and those types of or had summarized, in their letter of findings, summarized the violations that are conducted by the school, then that could be helpful or persuasive for other schools when you're conducting advocacy to advocate that they change their policies in a way that would not mirror what other schools have done when OCR found them in violation of Title IX. I don't know if I just made sense, but I think they could be helpful even if they're not formal statements of policy. And many of these letter of findings and resolution agreements actually are then, I don't think the letter of findings are, many of the resolution agreements are placed on OCR's website. And so what OCR tends to do after issuing a letter of findings is they try to enter into a voluntary resolution agreement with the recipient, so with the educational institution, who then agrees to take certain remedial actions. And that's when OCR begins to monitor their compliance with the resolution agreement. The consequence for an institution not agreeing to enter into a resolution agreement if OCR found they had violated the law, or for violating the resolution agreement and not agreeing to take steps to come into compliance, is that OCR could initiate proceedings to suspend or terminate their funding to the institution, which is a very significant and serious consequence and has not happened, to my knowledge, through an OCR enforcement. There was a case, I think, in 2018 where OCR, I think they suspended funding in Chicago public schools for Title IX violations. There was a pretty comprehensive report about those violations by the media involving K-12 students. But this was funding that was pulled through the Magnet School Assistance Program. It was not funding that was removed through OCR separate enforcement. And so in reviewing the school district's application for funding under MSAP, the Magnet School Assistance Program, OCR determined that they couldn't receive that funding because of Title IX violations. So other than that, I haven't heard of cases where there was a full-on suspension or termination of funding through an OCR investigatory process. And OCR at times could also conduct a facilitated resolution between the parties before the investigation finishes. So parties can choose to resolve the allegation with OCR facilitating the settlements, so kind of acting as the mediator, and the staff from OCR who is assigned to facilitate the settlement discussions would not be the same staff who are assigned to investigate. And in addition to processing complaints, OCR also conducts compliance reviews. So OCR may decide to open up a directed investigation or compliance review of an institution based on reports that they're hearing in the news, for example. So after, what happened at Michigan State University with their failure to respond to sexual abuse by Larry Nassar was uncovered by the media, OCR had then decided to conduct a directed investigation into MSU. Similarly, they did one at USC as well after allegations from the school gynecologist, George Tyndall, came to light. And then, as I mentioned, OCR also provides technical assistance. So that's available for students and families. It can be through phone or written inquiries. At times, OCR will also conduct workshops and presentations. Not sure how much of that they're able to do, but right now, but those are very useful, especially for educational institutions to educate them on how they're supposed to comply with civil rights laws. So I know I am very much over. So this concludes the presentation. I will take a look at your questions in the chat and hopefully be able to respond to some of them. Thank you.
Thanks so much, Shawali. There are a couple questions in the chat and the Q&A relating to OCR complaints, and Shawali will probably have a chance to answer that either during the presentation or at the end. And we'll move on to Title IX litigation. So very pleased to present to you all Alexandra Brodsky to talk about filing a lawsuit.
Hi, everyone. I'm Alexandra. As Elizabeth said at the start, I'm a staff attorney at Public Justice. And I am primarily staffed in our Student Civil Rights Project, which represents primarily students, as the name suggests, in race and sex discrimination cases concerning education. And so I'm going to talk about what litigation, primarily money damages litigation on behalf of student survivors of sexual harassment looks like. Those of you who have taken on these cases in the past will know that so much of these cases revolves around two opinions from the Supreme Court in the 90s, Gebser and Davis. And in those cases, the Supreme Court laid out what the four elements of what I'd call a standard Title IX sexual harassment case. So this is the model that most lawsuits try to fit themselves onto. And unfortunately, in these cases, the Supreme Court adopted a really high liability standard that is much harder to meet than sort of analogous sexual harassment suits brought against employers under Title VII. So for those of you who primarily represent workers in sexual harassment cases, I think you'll be particularly surprised about some of the requirements here. So the basic elements of one of these claims is that a plaintiff needs to establish that the defendant had actual knowledge and was deliberately indifferent to sex-based harassment that was severe, pervasive, and objectively offensive, and that the victim was denied access to education. So I want to break down what these mean a little bit. So first, and to start off with a contrast to Title VII, the defendant has to have actual knowledge of either the harassment itself or a report of the harassment. Constructive knowledge, which usually suffices under workplace claims, is not enough. So what does this mean as a practical matter? The clearest example of actual knowledge is when someone makes a report of the harassment to someone in senior leadership at a school, or someone in senior leadership actually sees the harassment happen. But as I'm sure many of you know, that's actually quite a high bar, especially when we're talking about K-12 students. There are so many examples of kids telling an adult that they trust of what happened to them, but that person not being high enough up in the food chain of a school administration for that to count as the school's actual knowledge. So, you have examples of a student telling a bus driver or a teacher, but because that person doesn't count as a quote appropriate person, unless they then escalate the report to, a principal or a superintendent who are sort of safely appropriate persons, the institution doesn't have sufficient knowledge. I want to flag that there are some circuits, including the 11th and the 3rd, that where a school can have actual knowledge if it has actual knowledge of substantial threat of something of the harassment happening. So the classic example of this is a school has received reports over the years of a coach who sexually harasses students. And so even if they didn't receive the report of your client's harassment by the coach, they had actual knowledge of the substantial risk. There are other circuits, including the Fourth Circuit, where that's harder to, they're more hostile to that kind of actual knowledge of risk theory. Okay, so then let's say that the defendant has actual knowledge. Now you'll need to establish that the school was deliberately indifferent. And again, contrasting to workplace suits where the standard is generally negligence. Here, what this means is that the school has to be clearly unreasonable in its response. And the good news is that that is at least usually a fact-dependent inquiry, which is appropriate for a jury. There's lots of good case law out there saying essentially that, which is a nice thing to put at the start of your summary judgment or your opposition to summary judgment brief. But it's a really high standard to address. And I will say that as a general matter, when a school goes through the motions of investigating a report, providing some kind of support, it is more difficult to reach that deliberate indifference. That doesn't, even if they mishandle the allegation. And that's not to say that a school investigating means automatically that it's not deliberately indifferent. Absolutely not. We just won a Fourth Circuit appeal where the panel said that an investigation and some minor accommodations wasn't enough to resolve what was ultimately a jury question. But it's definitely a harder case to make when the school knows that it has to do something. As to what the underlying harassment looks like. So Title VII requires that the harassment be severe or pervasive. Title IX requires that it be severe, pervasive, and objectively offensive. Why it makes any sense that students who are often children are required to suck it up until the harassment gets really, really bad when we don't expect the same of workers is really beyond me, but that's the world in which we are living in right now. And then the plaintiff must show that they were denied access to education. And this is one place where this seems, this is actually not as tough of a showing as it seems. This doesn't mean that the victim has to leave school entirely, even though that's an unfortunately common fact pattern. There's good case law out there about students not being able to, missing some classes, their GPAs going down, feeling a lot of anxiety in school, which keeps them from enjoying it, dropping out of an extracurricular activity. That is enough to establish this element. And the one last thing that I just want to flag is that for reasons that I'll discuss shortly, this has been complicated a little bit, but these kinds of suits often fall into what I would rather call a pre-assault case or a post-assault case. And what that basically means is the school liable based on its activity before the assault or harassment or after? And so a classic post-assault case would be student is sexually assaulted, they report it to the school doesn't do an investigation, or does a bad investigation, or doesn't offer any accommodations, and as a result, the student's education is injured. And we see there the school's relevant actions happen after the assault. A pre-assault case would be one in which the school knows of some kind of risk. They know that either this particular plaintiff or students in general are at risk of harassment, often because of repeated reports about the same person doing the harassment. They respond to that with deliberate indifference, and as a result, your client is sexually harassed. We can move to the next slide. So Gibbs or Davis are rough, right? Those are really high liability standards. So we at Public Justice and lawyers in this space across the country have been trying to figure out, well, what would it mean to establish liability outside of that specific model in Gebser and Davis? And Gebser itself says that the liability test that it created isn't going to be the right fit for every single case, that there might be other ways of showing that a school was liable. So the best established of these are what's called official policy claims, which is something that Gebser itself acknowledged might be the case, and have been acknowledged by the 9th and 10th circuits and district courts across the country at this point. And the basic logic of that, which will sound familiar to people who do 1983 litigation, is that the harassment that your client faced came about, your client was more vulnerable to, because of the school's official policy of deliberate indifference. And so in Simpson, which is the 10th Circuit case that really pioneered this vision of Title IX, and interestingly, which then Judge Gorsuch joined, the University of Colorado had a policy of basically using the promise of partying and sex to recruit student athletes. And the way that they organized these recruiting events put women specifically at risk of sexual assault. And so even though they didn't, that you can see how that theory doesn't quite fit into the Gebser-Davis model, because it's like, well, they didn't have actual knowledge of the particular incident, they didn't have actual knowledge of the particular victim, or that the particular harasser was a threat, but they had this general policy that made violence more likely. And this is sort of bubbling up in the courts now, and I hope to see more circuits adopt this. We've also been trying to think creatively about what happens when the sex discrimination isn't subtext, when it's text in some of these cases. So in Gebser-Davis case, the underlying harassment is sex-based. And then the school, by acquiescing to that or failing to address that, essentially adopts the sex-basedness of the underlying harassment. But let's contrast that to a case that public justice had in Oklahoma that settled last year, where our client was a young boy who'd been repeatedly sexually assaulted by his classmates. And the school said, well, if you were a girl, we would take this seriously, but you're a boy, which means this is just hazing. And so we're not going to do anything about it. Now, we could make a Gebser-Davis claim about that because the school failed to investigate, it failed to protect our client, but he eventually left the school. But they just said that they would have treated our client differently, but for his sex, and that's sex discrimination. And we moved affirmatively for summary judgment on that theory and settled the case the day after that brief was filed. We've also, so I think that kind of sex discrimination is probably going to be more, that kind of fact pattern is more likely to come up in representing male victims, though certainly not exclusively. I could imagine, you could get a principal saying, girls lie about these things as evidence of straightforward sex discrimination. And then we've also been trying to think about how to use sex stereotyping law in this space. So many of you, I'm sure, are familiar with Price Waterhouse, the Supreme Court case that said that a workplace can't make employment decisions on the basis of sex stereotypes, or the plaintiff's inability, or the plaintiff's perceived failure to fit sex stereotypes, expectations about how men and women behave, and particularly how good men and women behave. And so we have a case actually that we co-counsel with Carrie's firm, where our client, a high school student, a girl, when she reported her rape to the school, was met with a bunch of sex stereotypes. And to be clear, these weren't stereotypes about survivors who can be people of all genders. They were really stereotypes about women. So one was the school said, well, because she took basically 18 hours to report, that meant that she probably wasn't telling the truth. And I think all of us who've worked with survivors know that's actually an incredibly fast complaint, particularly from a young person. But if you look at the history of American criminal law, there were these prompt complaint requirements, unusually short statutes of limitations for sexual assault that were explicitly based on the expectation that women, specifically women, would naturally just immediately report if anything like this were to happen to them. Same goes, they said, well, she didn't fight back hard enough. And that is also a stereotype specifically about women, that, it would be such an affront to a woman to be, sexually imposed upon, that her natural instinct would be to fight back as hard as she could, even though we know that sometimes survivors put themselves at risk if they fight back. Many survivors freeze. That's a sex stereotype. And then she also faced aspersions about her credibility based on the fact that she basically had been in some way sexually active with a previous boyfriend. And, long history of American law saying that women, specifically women who were not virgins, their testimony was less credible, and that was a rule that did not apply to men. And so we argued, separate from a Gibbs or Davis claim, that that the school hadn't believed our client and had in fact disciplined our client because of its adoption of sex stereotypes. So, the last two bullets here are less well established than the official policy claims. I don't have great case law to point you to, but these are the kinds of theories we're trying to develop and that I'd be happy to talk about if you see these kinds of facts arising in your cases. Next slide. So there is a lot in Title IX case law that is still not resolved. There are a lot of open questions, some emerging circuit splits. And I just want to flag a couple of these for you. And if these are coming up in your cases, I'm happy to talk about any of these and provide sample briefing. So one is that there is a circuit split on the question of whether a plaintiff needs to be subject to further harassment after reporting in order for the defendant to be liable. And so what that's basically, the Sixth Circuit is the one circuit that has come out really clearly in favor of this requirement. And what their model is, a student reports that they've been sexually assaulted or sexually harassed in another way. The school is then deliberately indifferent. Unless that plaintiff experiences more harassment by the same person as a result of that deliberate indifference, the school isn't liable. And we think that this is obviously wrong, and most of the circuits have said it is obviously wrong, most recently the Fourth Circuit, and a case that we had, because sexual harassment is one kind of injury cognizable under Title IX, but at its heart, Title IX is an education civil rights statute. And so, for example, our client in this Fourth Circuit case reported to her school that she'd been assaulted. The school failed to respond appropriately. And as a result, she didn't feel safe in school and took steps to protect herself at the cost of her education. So, for example, she stopped coming to the full band class that she shared with the person who had hurt her, and instead basically practiced in a closet. And so the fact that she wasn't sexually harassed is not evidence that the school did a good job. And there's similar cases where, say, someone reports to the school refuses to help, and so the person drops out. And that can hardly be said to, be evidence that the school shouldn't be liable. So that's a place where we're very focused. And if you have cases that implicate this, again, we have plenty of briefing and a filed amicus briefs as a law center and are happy to help out there. There are, and I should just flag, you can see how in the Sixth Circuit's telling there's no such thing as the sort of pre and post assault theories kind of get merged together. A school can never be liable just for what it does after the harassment. Also, different holdings and dicta among the circuits about whether a single incident of sexual assault can be severe and pervasive. Most say yes, but not all do. But another issue bubbling up is whether off-campus harassment that creates a hostile environment on campus triggers a school's Title IX responsibilities. Classic case of this is someone is sexually assaulted off campus by a classmate, has to sit next to them in math the next day, can't focus, can't learn as a result, starts skipping class. Does the school have to do anything about that? We obviously think yes, but courts are torn on this issue. And then I know we'd gotten a question about this ahead of time. What happens when someone is both a student and an employee? Or if someone is an employee at a school who might then be protected by both Title IX and Title VII? Courts are coming out in all kinds of ways about whether Title VII is an exclusive remedy for sex discrimination for employees in schools. Basically, if someone is subjected to, let's say, this often comes up in pay discrimination, can they bring both a Title VII and Title IX claim, or can they only bring the Title VII claim if both are available to them? Again, I think the right answer is no. There's good case law out there saying no, but I would check, where you are in the country might influence this. And I should flag, one thing to keep in mind there is that a Title VII suit will generally require filing with the EEOC before litigation. Someone bringing suit under Title IX does not have to file, exhaust OCR's investigation before filing in court. And then a last thing, which PJ has been focused on a lot recently, is efforts by defendants to narrow essentially who within a school is protected and what parts of the school are subject to Title IX. So I have the text of the statute here because this is actually a place where we should all be textualists. So Title IX is a really broadly worded statute. So to start off with, it says that no person shall be subject to these forms of discrimination. But defendants in early Title IX history tried to say that no person actually just meant no student. The Supreme Court corrected that, saying no, an employee could bring a suit. Now we have a case, for example, right now where a school says, well, an independent contractor isn't a person. Or another case where they say a young person enrolled in a summer camp run by a university is not a person. So we are arguing that they are in fact people. I think that we're right about that, but it's something, I will be blunt that I've seen this briefed poorly. And so I think there are easy traps to fall in, but ultimately the text is really our savior here. And the other place where we see defendants trying to narrow the broad text is what counts as what parts of an institution are covered. So program or activity in the text is defined by the Civil Rights Education Act to include all of the operations of a university or school. And so long as a university or school is an education university or school, which all of them will be, it's an education program or activity. But we still see defendants saying, oh, well, only the core academic functions are covered, or only the core academic functions and athletics are covered. And I think relying on this intuitive sense that Title IX is really only about education in the traditional sense, even though Congress has been incredibly clear that really is the whole university. It's the bus, it's the public campus. It's really all of its operations. So again, if you see any of these issues coming up in your cases, please feel free to reach out to see if we have any resources to offer. And I think that's all my slides. Now we're on to Q&A.
Thank you so much, Alexandra. And thank you to everyone who's been asking questions in the chat and in the Q&A. Our panelists have been answering some of these questions during the presentation, so you can take a look there to find out what the answers are. And if you have follow-up questions, please feel free to drop those in the Q&A or in the chat. And there is one question right now, Alexandra, for you from Valerie. Valerie is asking, for the deliberate indifference standard, do you have any ideas on how to respond if a school claims that they were restrained because of the respondent's IEP?
Yeah, that's tricky. And I will be honest that that's not something that's come up in one of our cases, but I'm aware of the concern. One thing I would say is there's a lot of focus in conversations about Title IX and sexual harassment on punishment, on discipline. And it is certainly true that there are circumstances where someone is just not going to be able to learn until the person who hurt them is suspended, transferred to a new class or a new building. So I'm not saying that discipline is not part of the equation, but there is so much else that a school needs to do in order to support a student to make sure that they can learn in the wake of violence. So even if that school might have had genuine restrictions, one question would be, were the restrictions genuine? And I don't do disability law in any kind of real way, so I'm the wrong person to answer that question. But even if the school really was restricted, there's still so much else that they could have done to get your client mental health care and academic accommodations so they can catch up in school that in no way infringes on the rights of the accused.
Thanks for that answer, Alexandra. It doesn't look like, it looks like there are some new questions now. Lauren Hunt had a question. Have you had any cases wherein the victim and the perpetrator attended different schools? Does Title IX have any obligations in either school to either provide accommodations or to investigate, even though they're in different institutions?
I can answer, I will answer just really quickly from a litigation perspective. That I think that the question, there is no reason why that categorically could not be true that a school would have Title IX responsibilities, but to remember to frame it around whether the survivor has been denied benefits access to the defendant's program or activity as a result of the harassment or the deliberate indifference. So there is a First Circuit case basically saying that if student A is assaulted, if one student at one campus is assaulted by a student at another campus, that you would need to show that, I'm not explaining this well at all. There was a student who was from Providence College assaulted by a student at Brown University who said that the assault deprived her, that Brown's deliberate indifference deprived her of access to education at Providence College, and that wasn't enough. She would need to show that she was denied access to the benefits of Brown, which she didn't need to be enrolled there, but needed to show some connection to their programming.
Go ahead, Carrie.
I would add to that from a litigation perspective, and then I'll speak to the disciplinary process, is that might put them on notice of a risk of a risk of harassment. So learning about it elsewhere they could still have obligation to the next student. So that's like a different way to be thinking about it from a litigation standpoint. From a disciplinary standpoint, I have had students at different schools where both investigate, where one investigates, but your question is, does Title IX obligate them to? And under the DeVos rule, there's like a lot of limits on when they are obligated to under Title IX. That has really so there's what litigation is also what they have to do, right? Like what the courts say they have to do, and they have to address, they can't be deliberately indifferent to a known risk in most districts, or in my opinion in all, right? And so that's one way to think about it from what the current administration is saying. They're really limiting that in many ways. So like you'd have to go through that like looks to me already like a question that has like multiple hurdles because of where the location is and where the risk, whether or not the respondent or the complainant is getting access to their education at that time. So there's probably, that looks to me like some Title IX hurdles, but that doesn't mean that the schools wouldn't do it. They also have discretion to do it.
Thanks, Alexandra and Carrie. Oh, Shwal, you want to jump in?
I was going to answer another question as I was typing, and I figured it might be easier to answer it.
Can I also give one quick response to this current one while we're still on it, and then jump to you, Shwali? I think one thing to keep in mind too is that for K-12 students, if they attend different schools, but they're in the same school district, then the school district is the recipient. And so the school district is required to, under Title IX, address that harassment. So that would include both providing accommodations and investigating. And then for higher ed, a lot of schools belong to consortium. And so there is Title IX. There are Title IX regulations that talk about the obligations of schools to address sex discrimination when they have opportunities for students to get credit or other educational opportunities at other schools within a consortium. And so that language is not specific to sexual harassment, but it does mean that if a school partners with another school in any way, for example, cross-registration, and they're allowing students to receive educational opportunities from that other school, then this school, the home school, has the obligation to make sure that its own students are not experiencing any form of sex discrimination, including sexual harassment, while they're receiving opportunities from that other school. And I can find that and drop it in the chat. Go ahead, Shwali.
I was just answering the question about the notice of charges, and I was better write it down. So I don't know if we can move forward on to that question before I hop off. Yeah, I think that's the next one. So there isn't a timeline requirement for the Title IX grievance process, unfortunately, like how long the entire process has to last. I don't think there is one for notice of charges, but I know there's some timeline in the DeVos rule around like reviewing the investigative report and the evidence for post-secondary institutions. The investigatory process moves on to a hearing. There was, under earlier guidance that's now rescinded, a recommendation that these grievance procedures conclude within 60 days. I think 8 months is very long for a notice of charges. I'm curious what Carrie thinks. But Title IX does require that grievance procedures be prompt and equitable. And while the DeVos rule doesn't specify a time requirement, I think arguably 8 months to issue a notice of charges is not prompt. But yeah, Carrie, wondering if you have other thoughts to add on that.
8 months is not prompt under Title IX's requirement for prompt proceedings or the Clery Act's requirement for prompt proceedings. Also, and maybe Alexander could speak to this, but from a litigation perspective, there's also like a line of litigation that talks about delay being like access denied, right? Like that delay. So I've seen several cases where a delay of a certain number of days like was significant to be deliberate, could be act as deliberate indifference rather than like never do anything, take 8 months to do something, also could be in the category of deliberate indifference if this person is still suffering in their education environment. So I think you can push them on both Title IX Clery from the ED's perspective and from the court's perspective. That's not appropriate.
Yes, there will be a recording posted after we finish, and we'll also be sharing slides. It looks like those are the only questions for now, and we are at 2:31. So just want to thank everybody again for joining us. This has been a really great participation from all of you. And if you have any further questions, you can reach out to any of us. You can reach out to me as well, or reply to any email where you got any invitation about the webinar. It will make its way to us and we'll make sure to answer your question. If you're not part of Legal Network and you're interested in joining so you can receive inquiries from students facing sex discrimination, please let us know. Again, contact anyone, including Legal Network at nwlc.org. And yeah, thank you again for joining us. This has been really excellent. Have a great day.